Okay, the last problem-solving court we're going to look at, or I'm going to lecture to you about, is the domestic violence court model. Again, this model is based on two premises. One, to address a significant problem in the way that domestic violence happens and the reluctance of victims to often testify against their abusers. The second is to punish and rehabilitate offenders so that we can break the cycle of domestic violence that often occurs among offenders. The reason this model was developed was to specifically address the inherent problem that even though a domestic violence victim may not want to pursue charges against their offender, the state is required by law to prosecute individuals who commit domestic violence assaults and other crimes against an intimate partner, whether it's a husband and wife, boyfriend and girlfriend, or same-sex partners. Despite the fact that victims oftentimes do not want to pursue, police officers throughout the United States are required to make arrests if probable cause has been developed to believe that an individual has committed a domestic violence offense. Likewise, when those arrests come to court, prosecutors must also prosecute offenders if a crime has been committed. In some jurisdictions, such as the one that I worked in Hartford, Connecticut, and other jurisdictions throughout the United States, prosecutors' offices have developed a system or model of prosecuting offenders called vertical prosecution. Vertical prosecution means that a prosecutor is dedicated to prosecuting domestic violence offenses from the moment they come into court at arraignment to a conclusion, whether that conclusion involves successfully completing a domestic violence battery program or further prosecution up to and including a trial. Again, this method frequently, like the other models that we have looked at, involves using a dedicated courtroom where the prosecutor works. The model includes a judge that's normally assigned to domestic violence cases as well, social workers and victim advocates that remain in the courtroom throughout the court session, and the victim advocate plays a very significant role. The victim advocate is the intermediary between the prosecution and the victim. In most domestic violence cases, there are programs for first-time offenders that, if they successfully complete a program that involves counseling, that may include not only anger management, but may also include substance abuse treatment, because very frequently domestic violence offenses are committed while an individual is abusing either alcohol, drugs, or both. And if they successfully complete the program, the charges are dismissed like they never happened. And sometimes, or many times I could argue, once individuals complete that program and they are brought to court for their offenses, they don't commit a domestic violence offense again. However, a good number of individuals do not stop after they've committed a domestic violence incident, and either make it through the program or don't make it through the program. That's why vertical prosecution is a significant step in addressing the problem. Prosecutors are able then to interact with individuals who are known to have committed domestic violence offenses. And by working with a victim advocate every day, the victim advocate often meets with the victim and will provide information to the prosecutor that maybe the victim doesn't want the offender to know. Maybe the victim doesn't want the offender to know that he or she wants the defendant prosecuted. And the way that that works is many times during pretrial negotiations, the prosecutor will speak to the defense attorney and tell them, listen, I understand the victim doesn't want your client prosecuted. However, the state is proceeding and we can actually subpoena and force the victim to come into court and testify against an offender. And we can express to the defense attorney that although the victim does not want to prosecute, the state is prosecuting the case under the mandated law of the state to pursue prosecutions. Similar to the drug court model, we can entice a person to plead guilty to what we call a cap. A cap involves a period of incarceration. For instance, the crime in Connecticut of assault in the second degree is a Class D felony. So if somebody is accused of an assault in the second degree, and either the victim is uncooperative with the state or wants the defendant to plead guilty but doesn't necessarily want the defendant to go to jail, we can offer a cap of 5 years to serve. And the way that works is similar to the drug court situation. A defendant pleads guilty and then engages in various counseling. It's more lengthy than the initial program where somebody earns a dismissal. We normally monitor them, again, from anywhere from 6 months to a year. And during that period of monitoring, the defendant must engage and successfully complete counseling, either a more intensive domestic violence counseling program, along with some substance abuse program, and that the person must not engage in any other violence towards the victim. If the defendant successfully completes that program, they don't go to jail for the 5 years. They may go there for a year, or they may go there for 6 months, or they may be able to avoid jail altogether, but be placed on a very strict probationary period, and the conviction will remain on their record. So that's how we attempt to resolve domestic violence cases when either the victim is not cooperative with the state or the victim wants the defendant to be prosecuted. Because in the alternative, if they reject all of those offers, the defendant will proceed to trial. At trial, again, the state can subpoena and force a victim to testify. And that has happened on a number of occasions. Sometimes it's very difficult to prosecute under those circumstances. But in my particular period, when I was on that domestic violence docket for 5 years, I had been successful in doing that in a number of cases. So that is the domestic violence court problem-solving model.